So easy. Item 13. Mr. Learned Counsel, Punojit Das, Learned Counsel, appearing on behalf of Mr. S.K. Mahanta, Learned Counsel, purpose submits that Mr. Mahanta has some personal difficulty, is indisposed today. Therefore, prays for listing of the matter after 3 weeks. Prayers a lot, list after 3 weeks. Mr. A. Banerjee? Huh? Appears on behalf of Mr. R. The Learned Student Counsel is present. Huh? Supplementary for this. Item 33. Yes. Hmm. Page. Page for 13 or 16. It's a common transfer order. It's not a single kind of thing. But separately, but it's a common transfer order only. Then? Page? Then? Petitioner exhibit the input note from the 15th whereby petitioner one of the officer who was transferred from his place of posting is blocked. I'm not understanding. What is this order is? Who was transferred from his place of posting as belonging to South Siribhumi Education Bureau and postage elements in Lanka. Lanka, this is Hosai. Then? How you are aggrieved? As per the guideline, my lordship, I am not correct. Yes, South Korea. It's like guidelines only. No enforceability. No enforceability. There may be a violation of the guideline, but no enforceability. You join, we'll direct them to join you. What is this? This is by one, Rahim Uddin Laskar. Then, till 23/3/2026, the impugned transfer order insofar as it presents concern shall not be. This is you have been transferred. You show us where you have been from where. There is one seven from the top line. South Siribhumi Education Block, Siribhumi, in the same capacity. Where is this other person? Where is his name? Sir, I'm asking, where is the name of that person? Where is the name of that person in this transfer order, sir? This is you. I am asking where this person whose transfer order has been. Huh? Huh? Rahimuddin Laskar. Rahimuddin Laskar. Is hereby transparent postage via Lanka Education Block of. You are in Hozai. Huh? Which district? Huh? Huh? Hmm. We are not concerned. We are concerned about your petition. This man, Rahimuddin Laskar, was transferred to Hozai district, Lanka Education Block, right? That has been stayed. Then you're transferred to South Sribhumi South Block. Hmm.
There is some standard position, my lordship. Well, that order I can already state, my lordship. I have been confirmed.
Hmm.
I've not handed over the document.
The problem is where she is supposed to go. That has been stayed. It's okay. I've understood. But there's a stay. Where she will go now? In that case, what is this? Huh? Who? No, we're not. In fact, we're not inclined to interfere. But problem is that in this man Rahimuddin has already been his order has been stayed where she is supposed to go. So let it be. You obtain instruction, whatever you want to do. Huh? No, any order cannot be passed. You are safe without order. Yes. But you have to make him. You have to implement him. That's up to you. Huh? Heard, Mister S.B. Laskar, learned counsel for the petitioner. Challenge made in this writ petition is to the order dated 15/03/2026, passed by the Deputy Secretary to the Government of Assam, Department of School Education, by which various what is this block elementary education officer, including the petitioner, have been transferred to various educational block in the block of the districts in the state. List of it is the contention of the petitioner that the transfer order is insofar as it relates to the petitioner has been passed in violation of the guidelines of the Election Commission of India as the place where the petitioner is sought to be transferred is the home district of the petitioner, and the petitioner has not completed 2 years in the present place of posting. The petitioner, next para, petitioner is before that, before that paragraph. Petitioner is sought to be transferred as block elementary education officer, Sonoy Education Block, Kachar, to South Sribhumi Education Block in the district of Sribhumi. Please, then you write, it is the contents of say. Issue notice returnable by 3 weeks. As Mr. 4 and 5? Okay. 5? As Mr. P.K. Bora, Learned Standing Council, Elementary Education, Department, K. Pukon, Learned State Council for Respondent number 4, and Mr. M.S. for Standing Council, Election Commission of India, enters appearance and accepts notice on behalf of so and so. Our extra copies be furnished to the so and so. List the matter along with, that's all. List the matter along with WPC 1651 of 2026. You cannot pass an order which will create upside down. You are there be whether we passing any order, you are safe. Yes. Okay. Will it be can we dispose of the matter? Are you ready?
Especially article 1 of the charge sheet. And the fact that my argument is twofold. Number one, that the charge itself was a defective. And secondly, that the punishment which was imposed upon me was a completely disproportionate punishment in view of the charge which was spent. So my thing likes to
You have the records. Do you have the records? I think for final determination, we need records. So we'll some other day in that case. You produce the record on the next day. You decided it. Dismissal. Okay.
And it's a major penalty. Reduction in pay by 2 scale.
Okay. MS R.S. Chaudhary, Learned Counsel for the petitioner. Considering that the matter pertains to challenge to the pertains to disciplinary proceedings, which culminated into imposing major punishment of reduction of pay by two stages for a period of 2 years, MS S. Barua, Learned CJC, is directed to produce the records. Next paragraph. As agreed to by the learned counsel to the parties, let this matter be listed on 7th of May. Obviously, once the records is called, produced, will dispose. 7th. Yes. What is the matter? Huh? You are for 2, 4, and 5. You are respondent here. In the writ petition, you are respondent. And review petition, you are. Why review?
That water possible copy by sufficient material facts, no particular measure the water in the title zone and the injunction petition. Injunction petition of the title zone that was considered. And the water passed by the purpose of the water of the petition, which is the number 681.
You challenge? Where it is? Okay. You are in review petition and item 4. 3 and 4. Ayub Ali Sarkar. What is the case? Which services have been provincialized? Who's your petitioner? And that provincialization is put to challenge by him. Okay. Who is working? Who is working? When there is a stay, how can this be another matter? You cannot work. Your provincialization order has been stayed. So how can you work? That you have challenged in the subsequent writ petition. Then there is a stay. Then how are you still in the service? You are not in the service. Both of you are not in service. Once it is stayed, how can you work? Are you working? Well, although the sumoto. Are you saying so? Despite the stay, you are working. So we'll draw a sumoto contempt on your statement. Are you working despite the stay of the High Court? Stay order. Yes, tell us. On your statement, we'll draw a sumoto contempt. For a time being, are you working despite the stay of the order? We don't know. Wrongly or rightly, there is a stay. You have a remedy. If you are aggrieved by the stay or the order of the court, you have a remedy. We are not concerned. No salary, no concern. Are you working or not? No, on your this thing statement, on your submission, will draw a contempt. All right. Doesn't matter. Wrongly, rightly, there is a order of this court staying the appointment of the respondent. Try to understand. If you are insisting, immediately will draw contempt. It doesn't make a difference. That's why I'm asking, are you sure? Are you still working? Okay, it's better. Huh? Who is appearing for what? Whom? Why from two sides? That's why I'm saying you are in 3 and 4. You are joined together. You join together. Doesn't matter, same person, same matter. Both of you are joined together. See. Huh? But same person, same issue. You join together. Many minds of the many lawyers will make a more the wiser decision to join together. Huh? That's why I'm saying you join together. Apply your mind. Don't create a problem. If you say, that's why I'm asking, I'm repeating, if you say that despite the order of this court, staying the appointment of provincialization of your service, if you are still working, we'll issue a contempt notice. Ha. Very wise. Very wise. Wise lawyers. Yes. Why? Heard, Mr. Learned counsel for the petitioner in WPC 3259 of 2021 and 8515 of 2019, Mr. D.A. Qayyum, learned counsel for review petitioner and petitioner in WPC 6810 of 2018, and also Mr. For respondent 9 in WPC 3259 of 2021. On the prayer of Mr. P.N. Sharma, learned standing counsel, elementary education, for the 3 weeks time is granted to file affidavit. Affidavit in opposition. Yes.
Item 6. Yeah, the father died in 2005. This 2001.
Huh?
The delay
No, this is something that
in
This is your same. Huh? Hmm? FCI. Of what? Division bench. Hmm. Huh. Yes. How? Your order. Huh. We have heard Mr. Order last occasion. Right? Isn't it? Where is? Huh? Huh? Mathura. Mathura. What is doing? UP. Huh? Okay. Yes. In this case, Jayanta's case, his father died in 2010. Only issue is, only issue is immediacy. It's a compassionate appointment. Huh. 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 Hmm. Hmm. Page 26.
Next, serial number 2.
Page 26. Hmm.
Here is
Hmm. Hmm. See, the following persons are hereby requested to furnish the papers document as required in the letter immediately to this office further necessary. Yes, then. Hmm.
respect your thing. Has been examined in light of, I don't, right, your, particular. And I, the policy which,
Hmm. 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 Hmm.
29 lakhs.
Hmm.
Concern appointed elect.
Hmm. Hmm. Whose father?
Thereafter, 560.
Yes.
580.
So why you are coming here? There's already a direction. There's already direction of this court to consider and what they have considered or not. Huh.
There. With my documents.
That I have understood. Hmm. You come to after page 32. What is the direction? You have approached this court.
Yeah.
There's a direction to consider your case because they said the agent when your turns come, they will consider. So now what is your problem?
My position was. No, my position was this serial. They have considered the lies. Then number. The observation.
It's okay. Earlier it was 17.
There's a for lower category, 29 in grade 6,
Yes.
page 38.
Hmm.
And
Yes.
now
Where you are?
59, page 38.
Submission of date of birth.
Somebody applied to get road post.
But in that case, it will take months to hear your case. That too a very simple matter of compassionate appointment. Where you have no indefeasible right. Tell us what you want. What's wrong here? Hmm.
Get from 17.
Hmm.
It's 49.
Hmm.
There are guidelines.
Hmm.
The guidelines is that page 47
Hmm.
up to B. Here,
Page 47. Yes. Hmm.
there is going to be guidance. Put the rating. The is on what is unity in the stock perspective. My other guide, this is one of the 25.
Hmm.
Guidelines question. Security list question. From that security list, they are appointing. I five option.
The date of death, retirement shall be the criterion for fixing the seniority roster for consideration of the application. Yes.
Yes.
Ha.
How much?
Has it not been fixed? The list has not been prepared on the basis of the date of death. Come to the gradually, come, sir. Ah, don't gradually. That's why I've indicated in this. I mean, phase will to hear your matter. It will take months together. I'm asking whether the list has been prepared on the basis of the date of death. Then where is that list? Yes. 57. Ha. Yes. Page 62. Hmm. Ha. Hmm. Where is your name? Hmm. Moloya Ghosh. Ha.
I give a death of sheep.
Hmm. Is it correct? Is it correct?
Yes.
Hmm. Yes. 2006. Hmm. 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 Ah. Yes. What basis, according to you? On what basis, according to you? How he has been appointed? He or she has been appointed? Huh? Ah.
Now, during the day, his father died on 5/2006.
Hmm.
Appointed, but not five, was not considered. Yes, lordship, again, lordship. Appointed.
Hmm. Which year? Page 70? Ah. It's from different places. Not the same place. Yours is Gauhati. 2008. Hmm.
Yes, what is that lordship? Why was the claim that you filed for complete appointment? The education qualification recorded. Somebody who to apply for 2 years of the higher education, he cannot be claimed by the senior to lordship. This lordship. Because of it. This legal voltage. Other lordship, not.
Hmm. This is of which year? Ah. Devabrata. Devabrata is which year? Tiwari's case. Huh? Two 2023. This Devabrata Tiwari's case, 2023, Supreme Court has considered all the earlier cases, then come to the conclusion that once the sense of immediacy is lost, keep it yourself. So there's the appointment cannot be made. But Mr. Roy, how you have done this? Your guideline says first, number one, are they still guidelines are holding? I mean, it's in vogue. You are following the guideline. Apart from the Supreme Court and High Court judgment, forget about it. Are you following the? I mean, you have the policy in vogue. Ha, ha.
That's case say. Serial number was 289.
It's okay. That is another aspect. That is in a sense of it's if the immediacy is lost, then they may not be on the stale claim.
They prepared petition name was 51. And Johnson Consul's name was 287. Then his case was rejected.
It's okay, but that will come to that.
And second-
First, come to the factual aspect. See, number one, you have a policy. Are you following the policy? Is it still? Is still involved? Then how you have appointed when your policy says that the senior, I mean the appointment should be made on the basis of the seniority based on the date of death. Then,
This has-
huh,
I have a pen instruction. They say the two points there. One is, in the technical grade, his qualification record was BSc Agri and BSc Botany Zoology. Other one is, they have accounts technical qualification was required. He's only BA. So we cannot appoint, he is the general category. That was a technical category, technical qualification was required. His qualification was BSc Agri, and therefore technically qualified, therefore he had to be appointed. Has to have this, qualification as per the rules. Our rules say that in order to appoint a person as AG, technical, he has to have the specific technical qualification. So, since the petitioner that in that the main name, who is my learned friend of that part, had the technical qualification, that was my instruction. Last thinking I also. Other one is also technical, these accounts, AGP accounts. Qualification is commerce. That is BA, and he's a practicing advocate for only.
BALLB.
Yeah. So he cannot be appointed by not the technical. This has got
See, the persons who have been appointed in a technical post where you are not where you are not eligible. Number two, if it is a fact that if you are a practicing lawyer, can you seek any appointment? You cannot. Your license may go. Your license may go. Huh? What do you mean by that? See, as a lawyer, you cannot seek any appointment and you cannot do any business. Then, are you a practicing lawyer? It's a noble profession. It's a good, profession. Forget about all this compassionate. See, he said senior counsel has said she is a active, promising and practicing lawyer in Karimganj. Cannot. If you are an active practice, you cannot. No. When you are a practicing lawyer, where? What job is above the lawyer? It's not a job as such, government job, but then it's a noble profession. Advise your client. It doesn't befitting. As a lawyer, you are demeaning the profession. That too asking for a compassionate appointment. A lawyer, if you ask for as a lawyer, sir, as a lawyer, if you want to ask the post of President of India, the Chief Prime Minister of India. Why compassionate appointment? That too in a corporation. Food Corporation of India. Ask for the highest post in the country. You are not less than anybody. Don't demean the profession. It's a good profession. One of the best profession I have ever seen. Of course, I have never been to other profession. Although I was about to enter some other profession, but then I missed the bus. See, lawyer, don't say. That's why I'm saying. You are undermining and demeaning the legal profession. Please take up that instruction. Since I'll be dismissing your writ petition, I'm not disposing of the matter today. I respect the profession, lawyer's profession. Think about it. And in the meantime, sir, you file an affidavit, file an additional affidavit showing that, huh? This, my view, I'll not record in the order today, but remember my view, court's view, and discuss with the client, the petitioner. If she is really practicing a lawyer, forget about all this thing. Huh? That may create a problem. Sir, that will create a problem for her career. A practicing lawyer seeking for a compulsory appointment, what is this? And that too, you are asking her to appear in person. You want to spoil her career. Suggest her, if you want to ask the highest post of the country, not on compulsory appointment. All right. Heard Mr. B. Malaka, learned counsel for the petitioner. After hearing the learned counsel for the petitioner at some length, it is noticed that the petitioner has brought on record, which indicates that brought on record to the extent that some persons have been appointed whose date of death of the deceased employees are much later in point of time, i.e. 2008, 2006, 2008, etc. Whereas the date of the father of the petitioner is of 2005, whose serial number has been appeared, whose name appeared at serial number 142, whereas those appointed persons at serial number, those who have been appointed,
Hundred eighty.
188 and 217. Next para. Although Mr. P.K. Roy, learned senior counsel for the respondents, on instruction submits that the persons persons who have been appointed whose names are are below the petitioner in the list have been appointed on the post, on a technical post where the petitioner is not eligible. This court is of the view that such stand be brought on record via an affidavit. Accordingly, the respondent shall bring on record the stand they have, a stand taken by the learned senior counsel. Within 2 days, 2 weeks, list after 2 weeks.
Yes, 7.
List the matter after 2 weeks. Yes. Hmm. 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 So you have not you are abandoning any all other challenge except to release this. What is called and what this should. Huh. They have said they have admitted that they where it is. Hmm. 33. So far as the accumulation concerns, sum of so and so has been found accumulated in his NPS account as per the statement taken out for NSD. Yes. Hmm. 27. Hmm. Ah, that's all. That's why I say other. He's not pressing. Ah. When 15 days you release within 15 days. Do you need any order to release? Because it's his money. Because he's not pressing any other grounds in the petition. We'll record that because it's his money. Because I find why you should give a direction when he's and his own money. We'll dispose it of or we'll keep it pending so that we'll record that they'll release, we'll dispose it of. Huh. Heard Mr. B. Pathak, learned counsel for the petitioner. And also heard Mr. C.K. Barua, learned CGC. CGC, learned CGC. For all the respondents. For all the respondents. Yes. The next paragraph. Although the petitioner had challenged the impugn letter dated 03/01/2022 passed by the Major Adjutant, 24 Assam Rifles. Where it is? Page 23. Page 23, huh? Adjutant 24 Assam Rifles. Assam Rifles only, huh? Whereby the petitioner the petitioner, whereby the petitioner is sought to be dismissed from service on completion of 3 years of desertion. Then thereafter, dismissed. Any order of dismiss? 68. Which was ultimately dismissed by an order dated 02/07/2022, comma, the learned counsel for the petitioner submits that the learned counsel, Mr. B. Pathak, learned counsel for the petitioner, clearly submits that the petitioner is not pressing the challenge made in the state petition, except for a release of the NPS. What do we call it? NPS amount or what? The amount. What is that amount? Except for release of an amount of rupees 11,90,385.86 as accumulated in his NPS account. NPS account. That's all. Next paragraph. The petitioner was appointed was enlisted in the Assam Rifles on 02/06/2005 as rifleman /GD under the Assam Rifles Act 1941. Mr. No, and after completion of his military basic training, he was posted to 24 Assam Rifles. What is CO? Is C/O, huh? APO. and thereafter he was posted at various places in the northeastern region of the country. The next para. Where is the rending something kind of letter? This is the letter. Hmm. Okay. The by the notice dated 03/01/2022. The measure. No. The petitioner was provided an opportunity to rejoin the service within 1 month of the receipt of this letter, failing which the provision of Assam Rifles Regulation 2016 would be applicable and the petitioner would be dismissed from service on completion of 2 years of desertion period. List of the ground of such notice was that the petitioner was granted 24 days earned leave plus 4 leaves journey period with effect from 22 April 2019 to 19 May 2019. An extended 5 days leave earned leave with effect from 20 May 2019 to 3rd June 2019. You just get it from page 23, huh? So and so, that you just sent. An individual and then the petitioner alleged to have failed to rejoin the duty on expiry of said leave and deliberately absented himself from duty without any information. Next paragraph. Consequently, by an order dated 02/07/2022, the petitioner was dismissed from service as rifleman within bracket general duty without pension and gratuity with effect from the order date of the with effect from the without pension and gratuity. Next paragraph. Next paragraph is noted above. The Mr. B. Pathak, counsel for the petitioner, submits that the petitioner is not pressing the issue and thus pressing the matter as regards the challenge to the orders, impugn notice in orders. However, the respondent authorities may be directed to release the accumulated amount in his NPS account as the amount is a contribution made by the petitioner during this his service tenure. List of next para Mr. C.K.S. Sarma Barua. Sarma Barua, ne? Learned CJC in his usual frankness submits that an amount of rupees 11,90,385.86 is found accumulated in the NPS account of the petitioner, which the petitioner is entitled to receive. List of the amount which is a contribution of the petitioner under NPS would be released would be released within a period of within a reasonable within reasonable period. List of next paragraph. Having considered that the issue raised not in the present date petition having not been pressed by the Land Council for the petition, having not been pressed, and considering that considering a prayer to the extent for release of the contribution amount under NPS, I deem it appropriate, and as well as agreed to by Learned Council for the petition parties, I deem it appropriate to dispose of this writ petition with the direction to the respondent authorities to release the amount, release the contribution amounts under NPS within a reasonable period of time, list of accordingly. An amount of a sum of rupees so and so 11,90,000 so and so accumulated. Accumulate in the NPS account of the petitioner. We released within a period of 30 days from today. 30 days from today, list of it is provided that any interest which has already accumulated in the principal amount of contribution, principal amount be also paid to the petitioner. Any amount, interest amount accumulate in the principal amount. Next one. Writ persistence disposal.
Ultimate.
Yes. Hmm. Hmm. You have been finally acquitted. Hmm. 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 And that was satisfied by the High Court, yeah, on appeal. Okay. Hmm. Hmm. During the pendency appeal, criminal appeal, what can we do now? Page, page 40? Okay. Hmm. Appeal is pending. What appeal? Well, ultimately, it has been converted, but then conviction has been affirmed. Huh? Hmm. That is, CCS was 975. 65. Just tell us. Can we take it up? Can it be disposed? Can it be, can we dispose it of today? Huh? But the facts are long. Huh? We'll have to record the facts. Issue may be very small. 19. Rule 19. Hmm. No opportunity was given as per this.
And for that, you notify and rely on one judgment per person.
Tulsiram Patel.
My case, and in fact, my
2000? 2000? Hmm.
PSCC program
2001, 3 414. This is name of the party?
and other.
Hmm. Surya Kumar. Tulsiram. No, no. Para 8. Tulsiram is 1985. Hmm. Okay. Yes. A decision. 2001. Hmm. The Tulsiram is also clear.
My appeal is after the on appeal.
Modified, but
Conviction is
sustained. Conviction is sustained, but modified. I mean, to converted to other section. I mean, yes. Ah. Hmm. Hmm. Pera? Ah. Wherein it has been provided entirely that where a person is dismissed or removed. However, a formal communication on consideration of representative could not material owing to the outbreak of such communication record approval. Betting by the company authority located from the so then we have to set aside that 2011. No, see, when the law requires that you should be provided with an opportunity, right? If you have violated that, after the conviction or what? After the conviction. So for that also you need to give them the opportunity to, an opportunity has to be provided. Huh? No, in that case, we'll set aside this order. Ah. But then, Mr. Borthakur, they'll definitely dismiss your appeal.
That is for them. They will have to apply their mind or say that.
I don't think.
That.
What is your age now?
Right. As per our reply, efficacy to our system.
What is your post? Chokidar. You have completed the thing. Sentence.
No.
Okay.
13 years of completion was.
Normative 325. So whatever you have undergone. So you are free man now. Ah. Continue at after 5 minutes. This Ponaram Bora is same case, similar case. This is ha. What is the where is that impugn order? This Punam is under which this is Assam Discipline Appeal Rules. I think this is perimeter with the perimeter with the CCS Rule 19. Same order will pass. No, do you have the copy of this order? coordinate bench. Direction was to consider the representation. In this case, to consider the appeal. Same, almost same order. We'll pass the order. Appears to be in violation of the thing, in view of the Tulsiram and all other. Right. Heard Mr. Dispose, huh? As Borthaland Council put the petition, and also heard Mr. SK Medi, learned CGC. Learned CGC for respondents. Pass the order, huh? The only difference is that is in Poonam's case, Assam that 1964 rules. Here CCS rules. Rule 19. They said you have, because of the COVID you could not. But you have not said anything on that. That the dismissal is correct or not, I mean it's legally made or not. Huh? I say you have filed the appeal after the disposal of the appeal, criminal appeal. Then will not interfere, will not say anything on the impugn order, will just say direct them to dispose of the appeal or not. Okay. Yes. Annexer R1. And your this thing. Region, okay, region page 83. ISAK Learned Counsel for the petitioner. Is prayed for by Mr. No, on the prayer of next prayer, Mr. B. Taluk, the Learned Standing Council, element distribution. Further, 2 weeks' time is granted to produce the documents, original documents, as directed by this court on 01/12/2025. List after 2 weeks. Same matter. List along with 10 and 11. Then yes, I have seen this is part hard. So will not say that. No, this 10 and 11 is part hard matter. Where has it been listed? No, order 10, you on the next date, you pray, you may make a prayer before the coordinate bench where these matters are kept order. This will be separate, it will be separately listed. You make a mention when this matter is taken up. We'll pass the order in item 10 and 11. It's item 10 and 11. We'll not say that it should be listed along with this. This coordinate bench will take a call. It is noticed that 11 also part hard. Both the case, it is noticed that both the repetitions part hard matter before the coordinate bench. Before list before the appropriate bench.
And then we are
Discipline proceedings. We'll list for hearing. Okay, heard, Mr. J. Patwari, learned counsel for the petitioner. Next para. Mr. D. Bora, learned standing counsel. Learned state counsel. Submits that as directed by this court. He has received the recourse list of as agreed to by learned counsel parties. Let this matter be listed on 28, so many matters, I think. 5th of May.
and 14.
Murugan. Yes. Records. Who is for? Who is for the respondent? Yes, CGC. Okay. So we'll record that. Heard Mr. A. Sharma. I, Ahmed, learned counsel for the petitioner. It is informed that records are yet to be received by the learned CGC. List of in view above. Let this matter be listed after 3 weeks on the next date. Learned CGC to produce the records. After 3 weeks. Then 4 weeks. Somewhere at first week of May, 6th, 7th May. Yes. So, what is the matter, Kumar Sahab? What to do? Hmm. 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 Voluntary retirement. What is the provision? But there were certain proceedings were there. On the basis of proceedings only, you have been, the order has been passed. You are dismissed, but then on appeal, it was converted compulsory retirement. Heard Mr. B. Kumar. Today, we have 20, today we may not have, we'll have to. We're rising at 3:15. Therefore, it needs a, deliberation. It needs a deliberation, yes. Heard Mr. B. Kumar, learned counsel for the petitioner. It is next para. M. Burman. It is submitted by MS M. Burman, learned counsel, that the MS, who is appearing in this? MS again, and CGC is on the legs in some other court, therefore fresh for listing of the matter some other day. Whereas allowed, list the matter after 4 weeks on 5th May.
16.
16 also. Ah. Ah. Again, same order. You are appearing. Huh? Who is in 16? Ah. And Mr. So none appears for the petition. None appears for the respondents. As spread for by learned counsel for the let this matter be listed after 4 weeks on 7th May.
17.
I'm
Yes.
being led by senior counsel Mr. K. N. Chaudhary in this matter,
Ah.
and he's before the division bench, your lordship. Therefore, I kindly pray this matter may be taken up after some time.
Not after today is not possible. Today is not possible.
So today is possible, but he's on legs before court.
Today this court is when will not be able to take up the matter.
Lordship, then some other day.
What is the matter?
Lordship, the matter relates to removal of service, removal from service of the
It will
petitioner.
take time. You do have the records.
Lordship,
Removal from service.
removal from service.
After disciplinary proceedings.
Disciplinary proceedings where the rules of natural justice were not
We'll
followed.
call for the records. All right.
Lordship,
We'll call for the. Do you have the records?
wow.
Heard Mr.
T. Kashyap, your lordship.
T. Kashyap and counsel for the petitioner.
Petition.
Mr. MS. You have no answer whether you have the records or not. Huh? You have the original records. What records do you have? Writ petition. Writ petition. Since the matter pertains to removal from service after disciplinary proceedings, and Mr. MS so and so learned counsel for the petitioner to produce the records. Huh? On the next date, as agreed to by and counsel for the parties, let this matter be listed after 4 weeks.
Lordship may fix a date.
On 7th.
Much obliged.
Don't fix same matter and not be possible.
18.
Wait, please, your lordship. Matter pertains to area salary of the petitioner, lordship. So, lordship, on last occasion, AZ has submitted that they have released the salary slip.
Yes.
So, it is upon the department, then the money is hanging between the finance department and the health department, lordship.
Now, Lordship, my telephonic instruction is that the proposal has been sent, but the sanction is awaited, Lordship. So, Lordship, once the sanction comes, Lordship, immediately, and Lordship, similar matter, Lordship, of the same petitioner is listed on 21st, Lordship, of this month. Can this matter be taken along with that, Lordship?
21st of this month. It's over.
Lordship, that's it.
Subject matter might be different, lordship. That is-
Last. So, Lordship,
But
Has
proposed.
already issued the pay slip of the petitioner from so and so, and based on that, the area salary has been calculated department as so and so, therefore honors of penalized with the department. Mr. Opinion learning will press for weeks time to obtain it. Yes,
Lordship,
same prayer.
my instruction is that, Lordship, the department has already forwarded the proposal to the government, Lordship. So now the sanction is awaited, Lordship. Once it is sanctioned, Lordship, it will be released.
Lordship, proposal has been submitted since 2019, Lordship. Annexer
Have you signed it?
every year they send proposal, Lordship, by the additional chief medical and health officer. And I am 71 years old, Lordship.
This proposal will have to be submitted, Lordship.
Payslip already been, you have issued already,
Yes, Lordship, it has already been submitted, Lordship.
you pay within 1 month.
Yes, Lordship.
It will come up on.
Lordship, I'm 71, Lordship. Kindly see. And I'm 71 years old, Lordship. Unnecessarily money is hanging when the salary.
Nowadays 71 is Madam Young.
There also, Lordship, it's a matter of area salary, Lordship.
Yes.
Yes, Lordship. Yes, Lordship. Yes, Lordship.
1 week,
Lordship, no. 2 months.
2 months is sufficient.
2 months.
Yes, yes.
Okay.
Fine, sir.
Heard MS
K.A. Pujari.
Learned Counsel for the petitioner. And also heard Mr. D. Upamanya, Learned Counsel for the Learned Standing Counsel, Health and Family Welfare. And B. Sharma for Respondent Accountant General. Standing Counsel. As well as Mr. S. Alia for finance. Then you first write S. Alia, na? Then B. Sharma. Mr. Chalia, you are the main thing. They have already submitted.
No, the proposal has been submitted. Sanction is awaited from the government.
Their salary is on function the parent person, if they have the budget, if there is a budget is finished, then they send out the proposal.
Okay. By filing this writ petition, the petitioner has prayed for a direction to the respondent authorities to pay the area salary amounting to rupees 7,12,930. Mr. For the period
1-1.
01/01/2013 to 28/02/2014. Next period. The petitioner was appointed as medical and health officer. Dash. I think it's hyphen Roman 1. Capital Roman, for temporary basis on 10/12/1993. In the Berlimari State Dispensary, Nagaon. Nagaon, huh? Nowgo. Nowgong. In the Department of Health and Family Welfare, Government of Assam. Thereafter, a service was E or C. This service was regularized by an order dated 18/07/1996. Mr. Next period. Well, the petitioner was serving in the said capacity. A departmental proceedings was drawn against him alleging unauthorized absent from the service. However, same was dropped. Stuff. Thereafter, the petitioner was promoted to the post of senior medical and health officer by an order dated 06/05/2013. This period is for on what account?
This is for 1/1/2000. Originally, it was lordship for
Why?
I have received part payment lordship, but 7 out of that 19 lakhs, till 7 lakhs is pending lordship. Originally, it was 19.
On account of what? This period? Why you have not been paid?
Because I had an departmental inquiry after that they have given me promotion, and there's a lordship kindly come to pay speaking order. Lordship kindly come to page 48, lordship.
What is this?
Yes, lordship. Lordship, this one, Dr. Mohan Sharkey working as in findings, lordship. There is a department inquiry about the non-attendance of duties, lordship, but that is not true. After the inquiry, they find that he is on duty and he has given retrospective promotion. Initially, it was they have given for one. Lordship. Let me read, lordship. The lordship, in the finding section, while Mohan Soikia was working as MNHO at KKCH Golaghat, a department proceeding was drawn up against him and for alleged unauthorized absence without consent of authority. Accordingly, the promotion in respect of Dr. Soikia was kept under sealed cover. Finally, the departmental proceeding was closed by so-and-so, allowing consequential service benefit. He was promoted to the rank of senior medical and health officer by HLS so-and-so, dated 6/5/2013, lordship. That is retrospective promotion I have given for that, lordship. They have actually in the health department, they required for salary retention order. Yeah, but they have submitted ex post facto retention order. That's why this whole things occur, lordship. Initially, it was area of 19 lakhs, lordship, but I received around 2016-17 some 12 lakhs. That 7 lakhs is pending, lordship. That is the case, Lordship.
Where you have stated,
Lordship,
where you have stated that?
7 lakhs, 19 lakhs, Lordship.
Yes.
Yes, Lordship. I'm coming.
There are 7 people.
Yes, Lordship.
Para 7.
Yes, Lordship. Page 10. 10. Yeah, 11.
Next para, you just read. Due to initiation of, due to withdrawal of departmental proceedings and consequence dropping of the same, comma, and total area salaries of rupees 19 lakhs. How
Yeah.
much?
19 lakhs, 11,000.
19 lakhs, 11,000,
030.
030
Yes.
was accrued to the petitioner. List of, out of which, not list, out of which some amount was paid to the petitioner. Mr. Huber, an amount of rupees 7 lakhs 12,930 rupees has not been paid. Mr. Despite repeated approaches, the respondent authorities has failed to pay the said amount. Said area and salaries for the period, particularly from 2011, 2013 to 2802, 2014. Next paragraph. Therefore, the petitioner pressed for release of the same, the release of the amount of rupees so and so, so and so. Huh? Next paragraph. Mr. B. Sharma, Learned Counsel for the Learned Standing Counsel or Learned Counsel? Standing Counsel. Standing Counsel, Accountant General. By placing the instruction, copy of the instruction that is 0206-2025. Submits that the Office of the Accountant General has already issued the pay slip for the period from 01/01/2013 to 28/02/2014. And based on that, the arrear pay and allowances has been calculated by department for an amount of rupees, and the department amounting to rupees 7,12,932 only. Therefore, the onus of payment, making payment now lies with the department, and the Office of the Accountant General has no further role in it. Mr. Upamane, D. Upamane, Learned Standing Counsel, next para. Huh? Health and Family Welfare Department submits that for payment of arrear in salary for the period of for the period 01/01/2013 to 28/02/2014. Amounting to rupees 7,12,932 has already been submitted to the government for sanction. List of as and when the sanction is received, same shall be paid to the petitioner.
Lordship, direction may be given to response number 3 also,
Mr.
because budget is not there. If then I have to come again, Lordship.
Having considered that the claim of the petitioner is not disputed, and also considering the submissions that the amount, the claim amount, there no arrear in salary in respect of the petitioner amounting to rupees 7 lakhs so and so, having been submitted for sanction of the government by the concerned department. I deem it, I am of the considered view that no useful purpose will be served by keeping writ petition pending list of accordingly. No, that's, it would be appropriate that this writ petition be disposed of with a direction to the respondent authorities to make payment of the arrears, admitted the arrear in salary of the petitioner amounting to rupees 7 lakhs so and so within a period of within a period of 2 months, within a period of months. Huh? Why 3 months?
Lordship, next one.
3 months.
All right.
3 months from today. 3 months from today. It is ordered accordingly. Huh? Writ petition is things disposed of. Why? 3 months from today.
Much obliged, Lordship.
Yes. Give it back.
19, my lord, pertains to denial of promotion, and in my reply, my lord, the so-called reply, I could find that the 2019 ACR was not communicated, and based on that, his promotion was denied, my lord. Lordship has passed several similar orders. Assam Rifle has taken a stand that I should have represented, but then without communication, how do I represent, my lord? Lordship has passed similar orders in other cases. Otherwise, 2019, all ACRs are good. 2019 was bad, my lord. Therefore, in 24, the ACR, my lord, promotion was not considered.
Yes.
Number
36.
from the second paragraph. But if the mention here is petitioner on being suppressed in the promotion side,
It Junior has never sought any institution remedy for which we attach to submit representation under section 15 of Assam Rifles Act 2006. Moreover, the respondent had also introduced the redressal mechanism had Assam Rifles order dated 26/9/2003 to handle the defense related to the annual confidential report annual performance assessment. Instead of seeking the institution remedy, the petitioner served a written notice dated 16/9/2024 to his counsel. The same was given a reasonable reasoned reply by letter dated 17/10/2024. However, certainly indicating that a proper way of treating institution remedy is to commission a personal representation to the commandant under whom the petitioner is serving as has been examined the Assam Firefox Order 26 and 2026 the examining to the change of the commandant would be finally disposed of by the Director General of Assam Federal by examining the EQ annual compliance report, annual performance action report if found to be either technically invalid or uncommunicated adverse report. Hence, that is my submission, my lord. There is a mechanism, my lord, in the Assam Rifles Act. So.
Section 15 is a general provision of submitting representation, not
And it-
specifically on ACR. But then the question is, my lord, unless and until communicate, how do I on thin air submit a representation, my lord? And the law is otherwise well settled that, my lord, you cannot act upon this kind of entries. And I get to know only in 24 when my promotion is denied. That this is the reason that we have not considered.
This is post of
My lord, the
promotion to
promotional
the
post is Naib Subedar.
Next to be there.
Naib Subedar.
This order was in respect of earlier order,
Hello. I get law.
rank of Subedar. This is Subedar.
Yes, my lord. Subedar.
Same order. Not been communicated. We'll record your submission, para 6, page 36. That's all.
Hello. That's all.
Proper mechanism.
Heard Mr. B. Patel, done counsel for the petitioner, and also heard Mr. A. Gam, done in CGC.
Okay.
We'll pass the order in chamber. Say similar order is taken. We'll pass the order. Yes, disposed of.
My lord. Okay.
Item 20.
Yes, Mr.
P. Boiragi.
Heard Mr. P. Boiragi, learned counsel for the petitioner. Next para on the prayer of Mr. D. Pomani, learned counsel, learned standing counsel for Health and Family Welfare Department. Further 3 weeks' time is granted to file affidavit in opposition.
Item 21.
May I please? In this case, the affidavit has been filed by respondent, so lordship may allow 4 weeks time to file my reply.
On the prayer of Mr.
A. Chetri, lordship.
A. Chetri, learned counsel for the petitioner. 4 weeks' time is granted to file affidavit in the reply to the affidavit of opposition filed by the alleged contender. This after 4 weeks.
Well, this is a matter of 2017, Malak. Petitioner is seeking a family pension and some part of the salaries of the husband which was left unpaid when he died in harness, Malak. Well, in
Why this is listed for orders today?
Malak, actually it came on the top of the list on the last occasion, Malak, but Malak, Honorable Malak, Justice Nair, Malak, he cannot take up the matter. That's why Malak has been Malak.
Who was supposed to file affidavit? You have instructions. You have received the instruction. So that's why this has been, for filing affidavit, this is listed for orders.
Not exactly, Malak, because since Justice Nair couldn't take up, Malak, that's why.
Okay, heard Mr. M. Datta, learned counsel for the petitioner. Next para, Mr. P.N. Sharma, Learned Standing Counsel. Elementary submits that he has received an instruction to which he would like to bring on record by an affidavit. Therefore, phrase for 3 weeks time. File affidavit. Praise allowed, list after 3 weeks.
Well, I did my fix, 2017 matter, pension matter.
17 matter. Yes.
Yes, sir.
You have not filed affidavit.
No, so far.
I didn't realize 2017. It should not have been listed for admission. It should have been listed for admission.
Admission matter, admission hearing.
So that we could.
Now,
What is your instruction?
petitioner was appointed against the non-existent post without following his process at law. It comes under the illegal irregular category.
So,
And for those illegal irregularly appointed teachers, there was a screening committee constituted and all the.
Well,
okay. Okay, since you are granting
well,
time.
the appointment is as per
Give
the,
the date.
well, appointment is as per this honorable court's order, my lord,
हाँ,
and was only covered case, my lord.
ठीक है. We'll see. 29
29th of
April.
April.
My lord, 2018 order, my lord. Till
Yes.
date, my lord, they are not complied with the order. On the last occasion, if lordship kindly look into, my lord, that is
Ah.
order dated 13/3/2026. They have assured that, my lord, they have taken a prompt action for compliance of the order. Before this honorable court.
Lordship, we have sent a report to the compliance of the order.
Hmm.
So, Lordship will allow us some time.
Next week.
Lordship.
Next week. Or Mr. M. Chanda, learned counsel for the petition. Let this matter be listed on 6th, 6th, 05/4/2026. 6th next Monday, I mean, Monday. So as to enable MS D. Musahari and counsel for Alice contempt to obtain instruction. Ensure it is complied, otherwise we'll have to initiate.
My lord. Matter relates to the non-compliance of order dated 31/3/2023. Kindly peruse the last order,
Yes,
11/3/2026. Whereby
Mr. Chalia was there. Yes. You're supposed to update instruction.
This Purnima Horegate, all the people who were entitled to the sentence petitions. So Dipali Chaudhary's name was left out by the education department. Subsequently, a proposal was sent regarding the present petitioner, for which finance department has given the approval. For the same format, lordship, the similar steps have to be taken by the education department now.
What was the direction?
Grant the benefits of old pension scheme, to the petitioner's lordship. That's
Then,
the
madam, it's been under process.
yes,
Yes, my lord, there's one,
So we'll close it.
I have not instructed by my
Huh?
senior to.
It's not fully complied with.
Yeah, fully complete.
The speaking order has been passed by the education department.
They have passed it. You have to, on the approval of the finance, you will have to, the education department has to pass the order. Okay, we'll just, and keep it pending. Do it immediately. Huh? Add MS so learned counsel for the petitioner. It is submitted. No, Mr. H. Alia, learned counsel. for the respondent, Alice contender number 5 has. Huh?
Department, that will be the latest version. Yeah, this. The perfect for.
Mr. H. Elia and then in that case, Mr. H. Elia and counsel. And then Mr. H. Elia and Ms. MS. K. Das, your learned counsel for the respondents by placing the communications dated 30/03/2026. Communications, same dates, have submitted that the finance on the approval of the finance department, comma, and an appropriate order shall be passed by the Director of Elementary Education, comma, Assam. Affirming the entitlement of the petitioner in compliance of the order of this court. Let's please to consider above that this matter be listed after 3 weeks, 3 weeks, 3 weeks, the copy of the communications, that is so and so are kept on record and marked as documents X and Y. 3 weeks. You passed within 3 weeks.
Today is fixed for compliance report, my lord.
Yes.
Petitioner has already retired employee, my lord.
The director.
Huh?
The proposal has been received from the director immediately. Now we'll forward to the finance department.
Huh?
Now we'll forward to the finance department. So
You're supposed to have that this thing.
I need some time.
My lord, she has not received any pension.
Shall place before this court the order passed towards compliance of the direction. Huh?
Yes,
Then
time will granted, madam.
Last 4 occasion on same submission was then, my lord. I'm a retired employee.
yeah, it's not done.
Retired employee.
What is the order? Where is the order?
My lord, page 9 to 17. 16, paragraph 16 onwards, my lord.
What is this?
Third pyramid.
Today having
Without pension, without salary, my lord, the petitioner is suffering, my lord. এটা পাম না? আমি পাম না সেইটো?
when this order was passed,
My lord, 2 to 2024. And that was also upheld by the division bench also.
then they are planning to approach the Supreme Court.
Last of it,
They have stated in that communication.
The I heard Mr. N. Sharma, learned counsel for the petitioner. Mr. P. K. Barua, learned counsel for the alleged contender, by placing the communication, by placing a copy of the communication, submits that the authorities are under active consideration, are taking serious steps, serious and appropriate and serious steps to comply with the order of this court. Due to, therefore, please, therefore, press for some more time to comply with the court's order. Expert, without commenting on compliance or non-compliance, without commenting further. 2 weeks' time is granted today.
Let me fix, my lord. It's the last chance other personal.
That commenting. Sorry, without commenting on the submissions, come on. Let this matter be listed after 2 weeks.
26.
May I please, your lordship? Lordship, kindly peruse the order dated 4/2/2026.
Board,
I'm hearing on behalf of this D. Mushahari. She'll be filing a Vakalatama today, madam. He has received a Vakalatama.
Why this has been listed today?
My lord, the step was taken earlier twice, lordship. They did not turn into the notice. And thereafter the office note.
Heard Mr. M. Khan, learned counsel for the petitioner. It is submitted that Mr. M.S. D. Musahari, it is submitted by Mr. F. Khan, learned counsel, that Miss M.S. D. Musahari, learned counsel shall represent the alleged contemner. All
All.
alleged contemner for which he would be filing her power during the course of the day.
In respect.
Yes, sir, in view of
already
above,
as they-
let this matter be listed after 2 weeks. All right.
lordship.
Yeah.
The respondent number 3 is the person who is to implement, make the immediate compliance method. She has been served. Respondent 1 and 5, of course, the service notices, yes, as a service report yet to be received.
And
Is the
Miss-
finance department. Who has to-
Mr. M. Datta, learned counsel for the petitioner is and
I'll appear for respondent number 3, lordship here. Lordship, I'm for respondent number 1.
1 and 2.
4, 5.
Okay.
Then all are represented.
All are represented then.
Then you said heard Mr. M. Datta, learned counsel for the petitioner. Next page. The respondents, alleged contemnants are represented by Mr. H. Ali and Mr. On the prayer of the learned counsel for the petitioner, let this matter be listed after 3
Lordship, we have already received some instruction, lordship. I just need to.
3 weeks. 3 weeks, we'll make it 3 weeks. So as to enable them to file affidavit in reply. Affidavit in opposition.
Or compliance report.
Can I?
So we'll say the compliance report
Compliance report or affidavit, lordship.
to file the compliance report. We'll say compliance report.
Can I prefer date? It's a compassion appointment matter.
First week, last week of April.
Give that in.
Deputy Advisor, lordship.
28.
May I please, your lordship? This IA has been filed to correct the name of the respondent number 6, lordship.
We'll take it after that too.
Of life, lordship.
Resume too.
Item 28.
May I please, Lordship? Lordship, this IA has been filed to rectify the name of the private respondent number 6, Lordship. So due to typographical mistake in the cause title of the writ petition, her name was wrongly recorded as Porimita, Lordship. That should be Porimoni. Respondent number 6, my lord.
In
Lordship. In the writ petition, Lordship, her name has been recorded as Porimita, Lordship.
in the order or what?
Lordship, no, cause title of the writ petition.
Objection, any objection? No. Heard Mr.
PK Das.
PK
Das.
Das, learned counsel for the petitioner, and also heard Mr. Ms. Deborah, learned state. Learned standing counsel, Health and Family Welfare Department. For respondent number, opposite party. Is this applicant, huh? Opposite party number 1 to 5. Decision next para. Applications seeking the application praying for. Praying for correction of the name of the private respondent number 6. Private respondent 6,
Lordship.
which has been inadvertently shown as Paramita Gogoi in place of Parumoni Gogoi.
Lordship. Porimoni. Correct. One is Porimoni.
Stop. Next para. It is submitted that the the applicant while the connected in the cause title of the connected with petition 7132 of 2025. The continuation, same para. Next para. Mr. So-and-so learned counsel for the petitioner. Some applicant submits that the petitioner has filed a connected writ petition. Challenging what?
Challenging, Lordship, selection and appointment of some persons who are unqualified, Lordship,
Is
or
a-
underqualified.
Challenging the appointment of. This is respondent number 6.
One of them, Lordship, respondent number 6, Lordship.
Appointment of some persons as laboratory technician.
Lordship. Lordship.
Post is laboratory technician.
Yes, Lordship.
Laboratory technician. Pursuant to the advertisement dated 22/11/2014, 2014, including the respondent number 6, whose name has been inadvertently written as Parimita Gogoi in place of Parimoni Gogoi, List of. Therefore, he may be allowed to correct the name of the respondent number 6 Please stop. Next para. Having considered the submissions of learned counsel for the parties and considering that the name of the respondent 6 appears to have been inadvertently given as shown as Parimati Parimita Gogoi in place of Parimoni Gogoi. This is what you have not addressed the MS or Mr. or Siri, or you have not said anything.
No,
Parimoni Gogoi. I deem it appropriate to allow this application accordingly. The learned counsel to the applicant is allowed to amend the cost title in respect of respondent number 5 by correcting the correct name
6
as respondent 6 is correct by the correct name as Parimoni Gogoi. The IA stands allowed and disposed of. In view of the order passed, you file an amended cost title.
Right.
File an amended cost title. So and so, in view of the order passed in IA so and so, learned counsel for the petitioners to file an amended cost title. Next, on such filing, the registry to do the needful. This is for what?
My lord, I have been filed for infringement, my lord. Hello, one, my lord, Debras.
Yes,
Debras Park Chaudhary.
heard Mr.
A Manna.
Manan, learned counsel for the applicant, and also heard Mr. Ardhar, learned standing counsel, state counsel for the opposite party respondents. This is an application seeking implement of one Sri Debras Paul Chaudhary in the connected WPC 535 of 2024. Best of. What is your challenge in the writ petition?
My lord, challenge was made, my lord, impugn advertisement, my lord. During pendency of the, my lord,
Okay. The petitioner who is working as, who is appointed as,
as my lord,
you are still working.
district.
Are you still working?
No, my lord, my lord.
Who was appointed as district project manager within bracket PPM in the office of the district commissioner, Kachar, Silsar, on consensual basis on 11/10/2014, and whose services has been dispensed with. You are no longer there.
My lord.
On contractual basis. I said no, contractual basis. And whose services has been dispensed with, has challenged the advertisement dated
Dated
12/22/12/2023. Seeking inviting applications for filling up the post of
my lord,
district project manager.
Project manager
District manager
in the office of the district commissioner Kachar.
in the office of the district commissioner Kachar list of during the pendency of the connected writ petition. After due selection process, one Sri Devraj Paul Chaudhary, only one, has been appointed as district project manager within bracket DPM in the office of the district commissioner by District Commissioner Kachar pursuant to the said advertisement. Next para, Mr. Manana, then consent for the applicant submitted. The new appointee, the appointee, Sri Devraj Paul Chaudhary, would be a necessary party in the connected writ petition.
As respondent number 6.
Therefore, he may be allowed to implead him as respondent number 6 in the connected so and so, WPC, writ petition. Next para, having considered that since the advertisement is under challenge pursuant to which Sri Devraj Paul Chaudhary has been selected and appointed as DPM as a district project manager. The said person would be a necessary party in the connected writ petition. I'm of the considered view that the instant application is deserved to be allowed. Accordingly, same is allowed by permitting the petitioner, applicant to implead the said Sri Devraj Paul Chaudhary as respondent number 6 in the connected writ petition being WPC so and so.
In the
IA stands allowed and disposed of. Next para in the this thing. Writ petition in view of the order passed in IA so and so. Petitioners to file amended cost title. On such filing, the registry to incorporate the name of the newly impleaded respondent number 6. Thereafter,
notice may be issued to the
Notice
respondent number 6.
notice be issued and the respondent number, the learned council, receives be issued, returnable 4 weeks. Mr. So and so learned council for the petitioner to take steps by speed post as well as so and so. That's all.
High level, sir.
Item 30.
Regarding desirable and necessary qualifications advance. I have found 2 advance features. One is of 1996. Second, Health Department, person Dr. Anita Puri and others. And another one,
Same.
same area, 2019.
Para?
First one, 96 one, para 7 and 9. The latest one, para 9 and 13, 2019. 2019, 6 SCC. You also may take up that 2019 meter first. '96 meter has been reliable in this 19. Para 9 and 13. May I read para 9? The essential qualification.
Para 9.
Para 9.
Appointment to foster for employer to the employer may prescribe additional reserve college employer any grant. It is the employer.
The employer may prescribe additional or their
Candidate must for the record.
any grant of funds. It is the employer
who is best suited to decide the requirements a candidate must possess according to the needs of the employer and the nature of work. The court cannot lay down the conditions of eligibility, marks based, can it delve into the issue with regard to desirable qualifications being on a par with the essential eligibility by an interpretive rewriting of the advertisement. Questions of equivalence will also fall outside the domain of judicial review. If the language of the advertisement and the rules are clear, the court cannot sit in judgment over the same. If there is an ambiguity in the advertisement or it is contrary to any rules or law, the matter has to go back to the appointing authority after appropriate order to proceed in accordance with law. In no case can the court in the garb of judicial review sit in the chair of the appointing authority to decide what is best for the employer and interpret the conditions of the advertisement contrary to the plain language of the same. Now, para 13. Down below. The preference clause in clause 4.7 only means that if a candidate with the required degree qualification and practical experience in the manufacturing and testing of drugs for stipulated period of years has an additional desirable attribute of a research experience in a research laboratory. Other things being equal, preference could be given to such a candidate. The term preference, next page, mentioned in the advertisement cannot be interpreted to mean that merely because a candidate may have had the requisite experience of testing in a research and development laboratory, she possesses the essential eligibility and had a preferential right to be considered for appointment. Para 40 relied upon that 96 judgment. So essential qualification, desirable qualification cannot be equation.
No, that is, I have understood.
And as per the advertisement below, there are two categories, distinct categories, one essential, other one desirable. That means preparation.
What does this talks about the desirable? Para 13. If a candidate with the required degree qualification and the practical experience in the manufacturing testing over still period of years has an additional desirable attribute of research experience in the research with other things being equal, preference shall be given to such a candidate. This is something different.
The para 9 is most pertinent to the labor.
Employer may prescribe additional or desirable qualification, including any grant of preference.
So they have termed the desirable qualification additional qualification.
But one thing, this your the your what do you call it?
SLM experience.
SLM experience and ODL experience. SLM is what?
So the
We're not impressed about your clarification.
the
ODL, it talks about the working experience in ODL.
so
Open university, what is it called?
Distance and open learning university.
Working
Distance and open learning.
working experience in distance learning.
Open and distance learning experience. And my lord, so far my understanding is SLM is this type of book form, lordship. It's like a content writer. They have written some
SLM is no marks has been awarded to the respondent number 8.
lordship. This is
But ODL you have given. Why ODL?
regarding the testing of ODL experience.
Ah,
So, my lord, regarding that open means open and distance learning. In that arena, the candidates, my lord, knowledge and my lord, ability has been tested.
that is something different.
Different.
It is not the working experience.
No, my lord. That for working experience is that.
Or it is not equivalent with the working experience in the distance learning institution.
No,
That is what you are saying.
yes.
This is something which you have, although it has not been, you have already given in.
Yes, that has.
Although it doesn't provide under the, it's not prescribed in the advertisement.
Yes,
It's neither a desirable condition.
it's a desirable condition, my lord, regarding.
No, ODL experience.
No, not desirable.
Desirable condition according to you is one of the, apart from other thing, working experience in
Excellent.
Distance learning institution,
My lord.
which cannot be equated with the ODL experience.
My lord.
That is your submission.
Yes.
Is not it?
Yes.
Therefore, since they have no ODL experience, I mean the working experience in the distance learning institute, no marks was awarded.
Yes. All the 5 examiners, my lord, I have got 0 marks in that category.
No, that is LM, what is it called?
SLM experience.
Ah,
In fact, that SLM means self-learning material.
ah.
One will have to prepare SLM in ODL, course. So, for that, certificate of experience is issued by the competent authorities. And on the basis of that, that category, that marks in that category has been.
No, this. See, working experience in distance learning institute, what does it mean? What does it mean?
Their preparation of SLM, it is most vital aspect.
It is a, no, vital or not vital, it's not, we're not concerned. You have provided essential qualification. We have understood essential means if you have those conditions, if everything is equal, on the basis of the essential condition, not essential, desirable condition, sorry, one can be given preference, right? If everything is equal.
Everything is equal, then.
But one of the desirable condition is experience in ODL. Not ODL, can we say ODL or distance learning institution?
ODL experience. That is ODL experience.
Huh. So ODL experience, you have given marks to him, not in LMB.
In SLM.
Oh, sorry, SLM. SLM, you have not given marks to him,
Yes.
but ODL experience, you have given marks to him.
That can.
Huh?
The respondent number.
8. Huh. So ODL experience would be equivalent to working experience of in the distance institution.
So the ODL experience and SLM experience, 2 distinct categories, and my affidavit clarified all the aspects.
All the aspect, but then you, according to you, SLM is equivalent to working experience. Therefore, you have not awarded marks to the respondent number 8. That is what you are saying.
Yes. In that category, it is yes.
Huh.
That is why.
But then why you have said you have a column ODL experience. Now you are saying that ODL experience is equal to working experience.
Not working experience, the test of ability, test of knowledge.
Then how can you say that SML is equivalent to, in that case, working experience?
That category is SLM. May I take your also straight to that page?
I have seen that.
There are 2 categories.
I have understood. What is equivalent with the working experience?
The second category, SLM. That is working experience.
Then what is ODL experience?
That is not, depend upon the certificate issued by.
How can you say that this SLM? No, how can you say that SLM is an working experience? Or the SLM is, what does it mean?
Self-learning materials.
Self-learning materials, right? You must have that self-learning materials. All right. All right. How can this be a working experience?
Yes, my lord.
That working experience, one of the facets of that SLM experience. To prepare SLM.
No, first tell us what is your working experience? What are the would be the working experience in distance education, distance learning education?
It's the experience, it may be preparation of SLM in those arenas, certificates will be issued by the competent authority. And on the basis of those certificates, that SLM experience mark should be given.
So working experience doesn't include the ODL experience.
No,
What is ODL experience?
the test before the interview board, before the interviewer, the test and ability, knowledge in that area, in that open and distance learning area. One may not have those certificates, but he may have the ability, the knowledge in that area. That is why in the marking system there are two distinct categories. One is based upon the certificates, one is not based upon the certificate.
So you categorize it this without certificate ODL experience. And SLMB, what do you call it? SLM.
SLM.
SLM is a certificates which includes working experience.
Yes. So 5 marks.
Then why we call it self-learning material?
Since the preparation of self-learning material is done by the officer concerned.
When you have the self-learning material, there only you have the experience, working experience.
And furthermore, the preparation of SLM is one part.
Open distance learning experience. Doesn't convinced.
That is why my affidavit.
Your affidavit I've seen, that's why I'm saying I've understood what you want to say. ODL means ODL experience is what? Open distance learning experience. You didn't say the knowledge. You said experience. What do you mean by experience?
Yes.
That is, it will be as good as a working experience.
We will have to leave the way whether the nomenclature, ODL experience, ODL is a vast area, open and distance learning. SLM is one part of that ODL system.
SLM is self-learning material.
So, which self-learning material one can proceed with the ODL course. Without self-learning material, SLM, one cannot proceed with the ODL area.
So therefore, when the respondent number 8 doesn't have that SLM, which you have not given a marks, how can you give marks to a ODL experience unless he or she has a SLM?
He has been tested before the interview board.
So why you have said so experience? Why you have not said knowledge?
Maybe
No. This is something wrong.
Though
is it right to clarify that? That's why from day one, other day also I was not convinced. Nomenclature, I mean, when you say that experience, you
I admit,
clearly use the word experience.
I admit that nomenclature.
Your clarification indicates that it is the testing on the ability of the candidate as per the knowledge of the ODL.
My affidavit.
Your clarification. But then you said ODL experience. And the desirable condition, you said working experience.
Lord, I admit, Lord, if we concentrate only on that nomenclature, two words, then, my lord, the entire things will collapse, my lord.
Obviously,
But,
which is not required. You have done that. You have created a thing
but in the,
which is not a requirement of the advertisement, and you have ignored everything.
otherwise, my lord, we will have to use 10, 12 words.
Not 10, 12 words. When you are prescribed a desirable condition, qualification, the working experience in ODL, and you have given a marks to ODL experience, and now you are by affidavit you are clarifying that no, this is not experience, this is knowledge, testing of the knowledge. How can that be allowed?
Then that category we have to withdraw, my lord.
It's not a question of withdrawal. You have clearly categorized two this thing. One is SLM, other one is ODL experience. One could understand if you have given marks on SLM.
That is why, my lord, we will have to go back to my affidavit, my lord, and that has not been controverted. Only on that nomenclature, my lord. Only on that nomenclature, that it should be.
It's not the nomenclature. You have created something which is not requirement of the thing, and you have ignored what is prescribed.
That KK Henry.
May not be mandatory. The desirable condition may not be mandatory. But then you have given two. You have not this thing. You have not ignored that essential condition, desirable conditions.
In second category, we have not ignored. Second category, that SLM experience. But in the first category, it is a testing exercise before the interview board. Only that nomenclature, I admit, my lord, that nomenclature goes, my lord.
No, you cannot. When you provide something in the desirable condition, and you said since that desirable condition doesn't have, but you have shown that ODL experience.
May I read that desirable condition again, my lord?
Desirable condition says that working experience in the distance learning institution. That's all. And you have given a marks in ODL experience, which you are trying to say by affidavit, you are trying to clarify that ODL experience means the knowledge and the quality about the ODL by the candidate. And the SLM is a self-learning material which could be seen, which could include the working experience. That is what you have said. That's I am saying, not your submission. Your submission is correct as far as the affidavit is concerned. What I am on is your affidavit is not it's contrary to the prescribed qualification.
Lord, it is not.
Once the requirement is desirable, maybe may not be mandatory. Desirable condition or maybe a qualification is a work experience in ODL or otherwise it's in other words, distance learning institution. When that person doesn't have, how can you create a column, ODL experience and award a marks?
Otherwise, my lord, we will have to be satisfied only with the certificates issued by some authorities. That column is meant for the certificates issued by some authorities.
Of work experience.
Yes, my lord, that experience certificate.
Ah.
The second category, SLM experience. But the first category, it is for the interviewer to test the ability, test the knowledge. So there are two distinct categories.
That I have understood long time back. Other day only I said, how can you have that kind of stand? I'm saying, when your requirement is a working experience, you could have said that he doesn't have the working experience in all this thing.
Lord, As per my.
Your marks has to be on the basis of the prescribed qualification. Suppose you have prescribed that these are the qualification for PhD. Huh? Right. Then interview can award a mark having a column for MSc. Right. Or BA. If he doesn't have desirable condition, I mean qualification, it's not mandatory, I understand. But if the candidate doesn't have the PhD, right? How can he have created a column? Nobody is stopping you to test the ability in the interview, right? How can you create a qualification which is not there? Neither the essential nor the desirable.
It is the discretion of the interview board, the discretion of the authority. Since Miller.
No, it's not discretion. You cannot give a marks which is not prescribed in the qualification.
As an authority, we may not be satisfied with the certificates. So we'll have to test the ability.
That is other thing.
That is why that.
You test the ability, but you cannot prescribe a qualification which not you have not prescribed in the advertisement.
Desirable qualification.
Huh?
Since it's a desirable qualification,
Hmm.
so we can categorize in giving 5 marks to that desirable qualification.
Hmm.
So the private respondent number 8 doesn't have any marks to that category.
That is the I mean problem. That is what you are saying. But fact is otherwise. You have given a marks to ODL experience. What do you mean by ODL experience? Working experience, desirable condition is working experience.
Regarding that, I again repeat, my lord, that nomenclature, my lord, I'm also not happy with that nomenclature, but the practical aspects.
How do we know?
Have to,
We'll go by the record.
yes, my lord.
How do you change this now?
Please, from the records, my lord.
From the records, I'm saying your except your affidavit, your record says the otherwise. You have tried to explain.
Since, my lord.
Suppose if the essential desirable condition is working experience, can you, by filing affidavit, can you change it?
No, my lord. I'm.
That this is not a working experience.
I'm not intending to do that, and my affidavit is also clear, my lord.
It's not clear. When you have awarded a marks on an ODL experience, you cannot justify by filing an affidavit that is not an experience as such. It's an knowledge and testing of the knowledge and the quality of the candidate. That cannot be.
It's a practice, my lord. My lord, followed or long, my lord, and.
Sir, recently we had an interview. I was also a member of the board. We work out modalities, how to test the ability of the candidate. That is one thing. Nobody can, we cannot have a straitjacket formula. Here is a case, you are supposed to consider some qualification, may not be mandatory. By ignoring that, you have put one column or 2 columns of your own, which indicates that it is one of the desirable qualification. Then now filing an affidavit, you are saying that no, this is not an experience. This is the testing of the quality. I mean the quality of the candidate. How can this be accepted?
My mind.
Huh?
LLM.
Huh?
LLM is desirable qualification.
Huh?
So, my lord, in LLM category, my lord, I will get marks.
Huh?
But regarding experience in LLM course, regarding my ability, my knowledge in that LLM course,
Huh?
one candidate may not have that LLM degree.
Huh?
He should have LLB degree, essential qualification,
Ha.
but he may not have LLM degree,
Ha.
but he may have far better knowledge
Ha.
or better ability than an LLM degree holder. So
Ah.
a different category is created to test his ability in LLM area.
Therefore, the person
is
who
the-
who
one of
doesn't therefore who doesn't have the LLM has been given a marks
Yes, my
on
lord.
the
Yes.
experience and knowledge of the LLM. That is what you are trying to
Yes.
say.
Yes. In similar,
That will be a chaos.
no, my lord, that
How can you do that? Suppose on your same analogy, essential qualification LLB, desirable qualification LLM, and I doesn't have the LLM. It's not mandatory. Essential qualification I have the LLB, but you are awarding a mark on LLM, who doesn't have an LLM, on the ground that I may have a experience, better, more knowledge and experience in as regards the LLM than the person who is having an LLM. That will be bizarre. Very strange, sir. That is exactly what you have done.
my lord, those modalities have been, my lord, prepared by the
It's okay. Modalities, you cannot, contrary to the prescribed qualification.
my lord,
No one, all the candidates may not have that, the desirable condition.
my lord,
That will not make the candidate ineligible. But at the same time, you have given a right analogy.
my lord, I don't think it's not perfect analogy.
No, it's a perfect analogy which you have given. That is exactly what you have given.
My lord,
It was not coming to my mind.
the Supreme Court is clear in para 9.
Now, Supreme Court is its own context. I'll distinguish this.
Employer knows the best
But
and that
you
those
cannot
modalities-
have go beyond award the marks beyond the prescribed qualification.
the practical field, my lord, those certificates. Lord, your lordship, my lord, I should.
The
not-
real thing has come out from Mr. Foucault. The best analogy I have ever come across. I'll never forget in my life. This was not coming to my mind. That is exactly you have done.
In the practical field, my lord, it's a little bit like.
I've understood what they're trying to say.
So there is another category. Since the employer knows the best, whom to induct, Lord.
Okay, thank you.
Lord, if I am not so clear, Lord, another.
I'm clear.
Lord,
I'm clear, but then what I'm saying, what I have not understood, not the case. How you can do that? That is, I fail to understand. You are not supposed to do that. But then, since it is a desirable qualification, may not have that much bearing, unless you saw that because of this marks given to the respondent number 6 or 8, had these marks not been awarded, you could have scored higher than the respondent number 6. Now, that day we have seen it, even if these marks are deducted, you are still, he has, the respondent number 6 has scored higher marks. So in that case, otherwise he's.
But my affidavit reply may be taken into consideration. Here I have given some calculation regarding the marking. And regarding the knowledge and experience, heading number was that PowerPoint presentation and knowledge of computer. They have distinguished it lots. Knowledge, and there are also interview subject knowledge lots. They have distinguished everything lots. Of like that. Of life.
We are very grateful for the. hearing.
It's not CAB. I'll be dictating. Heard Mr.
Harfukon.
R. Foucault, London Council for the Petition, and also heard Mr. P.J. Foucault, London Standing Council, KK, HSOU, for respondent 126, and and 8, huh? Tabilda, Air Tabilda for respondent 7 and Mr. SN Borua, SM Borua for respondent number 8, huh? I'll pass the order.
Lordship, obliged.
7 and 9. It may take 2-3 days,
Lordship,
but I'm not keeping it CAB.
Lordship.
It-
Obliged,
CAB makes you lazy.
obliged, Lord.
Yes.
Most of that. 21.
As and when it is, yes, Mr. As and when it is completed, it will be uploaded.
Lordship, Lordship.
You'll get it, huh?
Obliged. Obliged.
Huh?
Second 31.
Yes.
My lord, matter pertains to a discharge from service on account of having 4 reading entries in his service dossier, my lord. Otherwise, my lord's matter is covered. Our coordinate bench has allowed the similar writ petition, my lord. The CGC is not available, my lord.
Or Mr.
Big-
B. Kumar, learned counsel for the petitioner. It is submitted by MS M. Burman, learned counsel, that who is not available. Miss MS Egan, she was here for before too. Okay, she's Egan, learned CGC, who is appearing in this matter on behalf of the respondents, is not in a position to appear before today due to engagement in already engaged in some other court. Therefore, first for listing of the matter after 3 weeks. As agreed to by land council, let this matter be listed.
My lord, this is a covered case, my lord. Any date after 3 weeks, my lord, it may be disposed.
On after 3 weeks on 13/05.
Deep your lordship.